So, what happens during redundancy and what are some of your rights? What are some of the things that you've got to think about when you're going through a redundancy process? Well, this video focuses on a number of these questions and hopes to provide some answers for you if you're in this particular situation. So, this video will particularly deal with if you have 20 or less employees going through a redundancy process. For what it's worth, if it's more than 20, then it is open to have things such as employee representatives, but we don't deal with that in this particular video. There's a blog on our website, magaralaw.co.uk, and you can find more information whether about this or loads of other employment law related topics to touch on. So let's delve in. First of all, each employee has the right to a consultation. An employer shouldn't just be bringing this up on someone and then handing them their notice, or not even handing them the notice and showing them the door. That is not how redundancy works. Legally speaking, redundancy happens where, for example, there is no need for that particular role in the business, or the place where that role is being carried out is being shut down, for example, or being moved further out where it's just not economically or commercially viable, for example, for employees in that particular office to travel to. For example, if an office is moving from the UK or somewhere in Birmingham, say, and is shipping over to Dublin. These are some of the things that may constitute redundancy. But nonetheless, there needs to be an input into the process that employees are allowed to have. And this happens during that employee-employer discussion or consultation stage. A number of things that need to be outlined are clear reasons as to why the employer's role could be being made redundant. So the employer needs to be told, one, that their role is at risk, and then there needs to be a discussion as to why, but also the employer and the employee both need to be able to explore alternatives to that redundancy. Now, things like that include things like flexible working arrangements or reduced hours. There are other ways, for example, things like suitable alternative employment that the at-risk employee may be able to do. These are some of the things that need to be discussed during this consultation process. Next, we also need to ensure that the redundancy process is fair, and employers get this totally wrong a number of times. And the way that to ensure that you make a fair process when choosing who may be made redundant is having something called fair objective scoring criteria. So these, in short, can't be subjective things like, do I like so-and-so and do I get on with such and such a person? They need to be objective factors that are scored upon with each particular employee, while still balancing and bearing in mind things like discrimination. Because I mentioned discrimination, for example, to do with things like disabilities. For example, an objective criteria could be attendance, but it may be the case that someone may be off sick because of something related to the disability, or indeed if they are pregnant or are even on maternity leave, then something like attendance may not score very well for someone who is in that particular circumstance. So there's so many things that employers actually need to think about which employers may not think about, but if we start doing these things, we can ensure that you automatically avoid as best as possible a claim against you as an employer. And indeed, if you're an employee and you feel or you think or you're aware that your employer has not carried out a fair process, then definitely get in touch, because that may mean that you may automatically have an unfair dismissal claim. So it may get to a point where you are made redundant. What does your compensation look like? What does your package look like? Well, along with things like your notice period or any other accrued but untaken holiday, you can expect a calculation made via a standard statutory government calculation, which gives you your redundancy package. Or you may be in a position where by your employment contract you have an enhanced redundancy package. But nonetheless, you may also get something called a settlement agreement. These were called, or are still sometimes called, compromise agreements, but legally speaking, we now call them settlement agreements. You may have one of those now, and in order for that to be legally valid and enforceable, you'll need to get independent legal advice on that. So whether you are an employer or an employee, employers make sure you get these drafted accordingly, and the employee is able to get independent legal advice. Employees, you need to understand that that settlement agreement is not just a tick box exercise for your solicitor. Settlement agreements contain things that may bind you. Certainly they give the employer peace of mind because you're not bringing a claim, but as an employee you need to make sure that you're getting the best deal possible, and the things that you're giving up by way of potential claims are worth it in terms of the compensation that you are receiving. So these are some of the things that you can think about with respect to redundancy. Do get in touch if you find yourself in this position.